Some senior advocates of Nigeria and other lawyers at the Supreme Court for the case to determine who should fund capital expenditures of state high courts, Sharia courts and customary courts of appeal. A former president of the Nigerian Bar who represented the Attorneys General of the 36 states, senior advocate of Nigeria Augustine Alege, submitted that the three courts are courts of the Federation and funding their capital projects should flow from the consolidated revenue of the Federation. He argues that the salaries and emoluments of the judges of the three courts are paid by the federal government and stressed that Section 81 of the 1999 Constitution should be invoked to place the responsibility of funding capital projects on the federal government. Mr. Alege's partner speaks further on the issue.
Now, over the years, particularly starting from 1999 up to this moment, the practice is that funding for the judiciary relating to the current expenditure has been borne by the federal government, leaving out capital expenditure, and that responsibility has been pushed over to the states. So the states have now woken up to say, no, you have wrongly passed responsibility which belongs to you, to us.
Counsel to the Attorney General of the Federation, Senior Advocate of Nigeria Tijani Ghazali, vehemently opposes the suit on the grounds that the section invoked is silent on funding capital expenditures for the states, even though the issue of salaries was stated as the responsibility of the federal government in the Constitution. He insists that this should be maintained.
On the substance of the matter, we are of the view that federal courts are different from state courts. It is the state's responsibility to take care of state high court, customary court of appeal, and Sharia court of appeal, and for the federal government to take care of Supreme Court, Court of Appeal, National Industrial Court, Federal High Court, FCTI Court. So they are shifting the responsibility to us, and we are saying no, it is their responsibility.
3 of the 5 friends invited by the court were in support of the suit for funding, while the other 2 aligned themselves with the Attorney General of the Federation.
For me, it is an innovation, it is a commendable one, and that we must begin to implement it such that judiciary will no longer be at the beck and call of a governor or of a president.
As you know, it has some perspective under which each one can see the interpretation. I adopted certain interpretation of law which did not allow me to align with them from the authorities cited, and the position of the law is as interpreted by and submitted to the court.
After listening to all the parties, Justice Mohammed Dattijo reserved judgment to a later date.